In this lecture, we're going to talk a little bit about what trademark law is for. What do we as a society get out of protecting trademarks? And at the outset, it's worth noting that trademark law is part of the federal structure of intellectual property law, but it's somewhat distinct from the other major IP doctrines of copyright and patent law. Copyright, which protects works of authorship, and patent, which protects inventions, exist to solve an incentive problem. The theory behind these two regimes is that providing a limited monopoly to authors and inventors is necessary to solve a free writing problem. So what do we mean by that? Because it's costly to write or invent, authors and inventors may not create in the first place if someone could come along and free ride off of their labor, copying the intellectual content of their works for free. So this concern is that someone who didn't spend years working on the great American novel or spend time in the lab coming up with an invention that works could just come along, undercut the original author or inventor, and then that author or inventor loses the chance to recover the costs of their creation and invention. And so patent and copyright law are there to solve this incentive problem. They give authors and inventors limited monopolies on their expressive works and inventions. Trademark law, by contrast, is not normally justified in those terms. It doesn't exist to stimulate the creation of novel, valuable IP like authorship or invention. I therefore think it's more worthwhile to think of trademark law as a form of consumer information regulation. Its domain is marketplace communications to consumers and the public at large. So what is trademark law there to do? Well, the Supreme Court has said trademark's goal is to secure to the owner of the mark the goodwill of their business and to protect the ability of consumers to distinguish among competing producers. And in enacting the Lanham Act, the relevant Senate committee stated that trademark law protects the public so that it may be confident that in purchasing a product, it will get the product which it asks for and wants to get. And on the other hand, protecting the trademark owner's expenditure of energy, time, and money from misappropriation by pirates and cheats. And you can hear in these quotes solicitude for both the interests of consumers and the interests of sellers. And it's worth unpacking that. And I want to start by thinking a little bit about what it is that we as consumers, as buyers, as people in society get out of trademark law. So, at the most basic level, trademark law is a form of consumer protection, ensuring that people get what they expect and avoid counterfeits, avoid fraud in the marketplace. So, most simply, basically, when you ask for a Coke, do you get a Coke or do you get some goodness knows what kind of mixture created by somebody out to defraud you? Now, that's important, but not terribly interesting. In a more interesting line, we might think of trademark law as minimizing or lowering what are sometimes referred to as consumer search costs. What does that mean? When you purchase a product, we might think of the total price you pay as the combination of two distinct expenditures. On the one hand, there's the price in money, what you are actually paying for the goods that you're purchasing. But the act of looking for the product in the first place, trying to decide what to buy out of the range of possibilities that are before you, also imposes costs. Say you're looking for a car. Figuring out which car to buy, the research, the trips to the dealership, the test drives, the negotiations, all of that is not free. And those costs of looking are part of your overall budget, if you want to think about it that way. We might think of the total cost that you're paying as being the money price plus your search costs. So, how might trademarks work to reduce those costs? Well, at the most simple level, we might think of trademarks as helping you generalize your past experience with a product to goods with the same name. So, I'm thirsty. I want to drink something. I want to rot my teeth. So I see Coca-Cola on the shelf. Is this Coke going to be like the Coke that I've had in the past? If the Coca-Cola trademark is protected, and if Coca-Cola is a company that cares about consistency and quality, I can rely on my past experience with the product when I see that trademark on the shelves. Also, staying on a simple level, if I have a particular brand name that I want, I'm looking for Coca-Cola, relying on the trademark, protecting the Coca-Cola trademark, lets me find the particular brand I want more easily. But we can think about trademarks and search costs in a more interesting way. One of the most useful things trademarks do is that they act as a vehicle for communicating product information. So say you're looking for a car, or you're considering a particular car for purchase, particular brand of car. Between you as the buyer and the person selling you the car, the manufacturer of the car, who has superior information about the product? Of course it's the seller. And so the seller is all too willing to assume the cost of gathering and communicating information about their product to you as the buyer. So we may think of the seller as the low-cost provider of information that buyers want to know, but cannot easily gather for themselves. So again, imagine you're out to purchase a car. Think about all the information that might be of interest to you. The price of the car, its miles per gallon, either in the city or on the highway, that kind of thing. The engine power, what kind of pollution does it emit? Is it a hybrid, an electric vehicle? What kind of space is there in the trunk? What kind of safety ratings does it get? Etc., etc., etc. You could gather all that information that you care about, but it's expensive to do so. But the sellers of the car, the manufacturers of the car, are all too happy to gather that information on your behalf because they have better access to it than you do. But of course, you're not going to be in direct conversation with General Motors or Toyota. Something needs to stand in for all that information. Enter the trademark. The brand name, the name of the product in question, can stand in as a receptacle of meaning for all the information that the seller is going to gather on your behalf. What does a Toyota Corolla cost? What kind of miles per gallon does it get? What kind of engine does it have? What kind of emissions does it give off? Once the trademark for a Toyota Corolla is up and running as designating a particular source of cars, it can now serve as a repository of meaning for all of the various kinds of information that the buyer may want to know and that the seller can gather on behalf of the buyer. And once we have this stable repository of meaning up and running, others can contribute information about the product as well. Things like product reviews, word of mouth, awards, news articles, and the like. And the trademark may embody all this information as a simple shorthand form of communication. You might like Eagle widgets for their price, I might like them for their quality, but the mark efficiently embodies and communicates both attributes at once. This in turn enables competition in price and quality among different sellers. You may have heard in the past a reference to something known as the lemons problem. Why is it so hard to find a good used car? The problem was described in the famous paper by economist George Akerlof. One of the issues you may have in a marketplace is that there is an asymmetry of information between buyers and sellers. In the used car market, for example, sellers know if their particular car is a lemon, and prospective buyers do not. So let's imagine a hypothetical consumer who has $5,000 available to use towards the purchase of a used car. Now, there are any number of sellers who are willing to sell that person a car for $5,000, but only a subset of those sellers has a car that is actually worth, by whatever metric we want to use in this case, $5,000. And of course, somebody who has a car that's worth that amount of money is probably not going to take much less than $5,000, whereas lots and lots of people are willing to sell a consumer a lemon, even though their cars are actually only worth $4,000, $3,000, $2,000, what have you. So what does the rational consumer do in that situation? Well, they likely discount the amount of money they're willing to offer to reflect the possibility that the car they're being offered is, in fact, a lemon. What does that kind of discounting do to the sellers of the cars that are actually worth $5,000? They're willing to sell the car for $5,000, but they're not going to sell it for $4,500, $4,000, or whatever the consumer's discount value is going to be to reflect the possibility that they're getting a lemon. And so those owners of the $5,000 cars are likely to leave the market for that particular buyer. So say the would-be buyer is now only willing to pay $4,500 after their discounting. Now the cycle repeats anew, and those who actually have a car that is worth $4,500 are driven out of the market as the consumer discounts their price again, and the spiral continues and continues until you're left with a market full of lemons. Now, of course, there's any number of ways to get around this problem. When I bought my first used car, I took it to a mechanic, and I had the mechanic inspect the car and tell me if it was okay. But that is, of course, a cost. What are ways that trademark law may possibly get around this problem? Well, we can imagine something like a quality assurance program and think about a service like CarMax that offers to sell used cars, but they bond the quality of their cars with certifications and promises of returns if something goes wrong. And because they're repeat players in the marketplace, they have a reason to keep those promises. Consumers know who to reward or punish as to whether or not a car sold by CarMax is or is not a lemon, and whether or not CarMax can or cannot be relied upon. But this only works if CarMax has a trademark that can stand in for their practices, that a car sold by CarMax means something that Deceptive Dan does not. This dynamic comes up all the time in daily life. So think about it in the context of, say, a road trip. You're driving across country and you're the kind of person who likes fast food, and you stop off the highway for gas, and then you're hungry, you want to get lunch, and you're somewhere in the middle of the country. You don't know exactly where you are. You haven't been to this part of the country before. And on one corner, you see a McDonald's. And on another corner, you see just some nondescript restaurant with no particular name. You look more closely, you see two E. coli walking out. Maybe they work there, maybe they're snacking, who knows what. But you don't know what you're getting. Whereas with a McDonald's, like McDonald's or not, the McDonald's you see in San Francisco is going to be more or less the same as a McDonald's in Boston, McDonald's in Chicago, Texas, Arizona, so on, so on, and so on. Why is that? Well, it's because McDonald's actually invests a lot of effort in bonding that a Big Mac is a Big Mac is a Big Mac. And that only works if McDonald's is able to be the only one selling under the McDonald's name, or more precisely, the only one able to franchise the McDonald's name, because McDonald's restaurants are actually owned by franchisees. But they all agree to certain rules in exchange for the right to be able to brand themselves as McDonald's. And so again, this enables competition in price and quality. But for it to work, consumers have to be able to find their preferred sellers and to trust the continuity of experience with those sellers. So all of these benefits require that a trademark be tied to a particular source, and only that source, to be this repository of meaning for information about a source or a particular product. Now, I've been talking about this as a benefit to consumers, but it's important to note that this is also, and just as easily described as, a benefit to sellers. The quality guarantee lets sellers charge higher prices in exchange for that higher quality, and it lets them compete on quality. But they can only do so if they're the only ones who get to stand behind a particular mark. Once they establish a particular reputation for quality, they are able to charge a price that reflects that reputation. This benefit to sellers is often described as protecting the goodwill of a mark. Now, goodwill has a lot of different definitions in a lot of different settings, so just to use a simple one for our purposes, think of it as the economic value of a consumer's positive associations with a particular seller. Trademark protection protects a particular seller's goodwill, thereby encouraging them to make investments in that goodwill. They have an incentive to go ahead and do so because they know that they'll be the ones who reap the rewards for doing so. No one is allowed to come along and free ride off of their reputation by copying their trademark. And so, to continue the idea of reciprocal benefits, the investments made in developing goodwill in turn benefit consumers, purchasers, buyers, because the way you build goodwill is by creating goods and services that are designed to secure the loyalty of purchasers and to be the kinds of things that consumers want to buy. So this is the happy story of trademark law. A more efficient market in which consumers who want to have certain guarantees of quality are able to get them at competitive prices, and sellers who are ready, willing, and able to provide that level of quality are able to enjoy the business of willing, satisfied buyers. But there are complications to that happy story, and that is the topic of the next lecture. Thanks for watching.